next speaker is an academic at UCD. He won the Oxford's Conington Prize in 2010 for Best Dissertation in Academic Philosophy, and he's a member of the Heterodox Academy. Thank you very much, Professor Tim Crowley.
Wow, well, Ronan and then Theo have really upped the energy, so I feel under pressure now. But I will get the brand of the hair dye that you're talking about. I need it. You don't need it. You didn't buy it? Okay, I'm going to talk about genocide. It's kind of funny. Well, no, it's not funny. Genocide's not funny. That's a bad start. But what's funny is in all the heat generated by Theo, well, by the hate speech bill in general, one provision of the proposed legislation, it has so far slipped under the radar somehow, and that is the proposal to provide for an offence, I'll quote now, of condoning, denying, or grossly trivializing genocide, war crimes, crimes against humanity. That's in section 8 of the proposed legislation. Now, it is a little surprising that this hasn't received much commentary. Firstly, because it is presented as one of the main reasons for the necessity of this act. And secondly, because its potential effects are at least as worrying, I think, as the rest of the bill. In some way, perhaps even more so. It should be of particular concern, I think, to defenders of academic freedom, given that it may seem to require something like accepting a state-mandated opinion on matters concerning historical events. Now, while this will be a new offence in Ireland, many European countries already have legislation prohibiting genocide denial, and penalties range from 1 year imprisonment to 10 years imprisonment. The Irish proposal in the bill is for a fine or imprisonment of a term not exceeding 12 months, or both, fine and imprisonment. Now, laws against genocide denial grew out of a more specific prohibition that many European countries had already enacted, that is, the criminalization of Holocaust denial. No less than 17 European countries have such a law against Holocaust denial, as well as Canada, of course, and Israel, perhaps more naturally. One can face prison then, in other words, for denying that the Nazi genocide of the Jewish people is true, for claiming it's a myth, or even that the mortality figures are exaggerated. Now, what is the motivation for the law criminalizing Holocaust denial? It seems to be a fear of history repeating itself, fear of a Nazi resurgence. One denies the Holocaust, presumably, in order to rehabilitate Nazism by downplaying or trying to downplay Nazi crimes. Now, it may be surprising then, given that, to discover that laws criminalizing Holocaust denial were not enacted, as you might expect, immediately after World War II, when such a fear might have seemed justified. Holocaust denial laws didn't appear until the mid-90s, in fact, when one might have thought that such fear seemed to have less justification. Now, there were certainly laws prohibiting Nazism as a political stance. For instance, the 1947 prohibition of National Socialism, a law passed in Austria, but that law did not mention the Holocaust until amendments in 1992, which prohibited the denial or, quote, gross minimization of the Holocaust. Even in Germany, an explicit prohibition did not appear until 1994. Admittedly, it had been punishable under a more general provision since the 1960s, but the explicit provision or prohibition against Holocaust denial did not appear until 1994. Now, Ireland is not among the countries that has such a specific law against Holocaust denial. What is proposed in the hate speech bill is the broader crime of genocide. Obviously, Holocaust denial would be included on this provision, but so too would other genocides. Now, it is worth asking whether such a provision would achieve what it presumably sets out to achieve. Presumably, our leaders have looked at the efficacy of Holocaust denial laws across Europe, some of them in place since the 1990s, as I said, and wondered to themselves, Does this work? Well, does it? What have Holocaust laws achieved? In his fine book, Free Speech, Timothy Garton Ash points out the following. The list of European countries with Holocaust denial laws includes some of those with the strongest right-wing xenophobic parties on the continent, from France's National Front and the Vlaams Belang in Belgium to the Greater Romania Party. Holocaust denial laws, Garton Ash continues, have not prevented their vigorous and dangerous growth. If anything, the bans and resulting court cases gave their leaders the nimbus of persecution that far-right populists love to exploit. So there is a lesson here, albeit one that our progressive leaders seem unable to appreciate. But just as Holocaust denial laws seem ineffective and even perhaps counterproductive, hate speech laws in general seem to suffer the same flaw. For instance, the justification we sometimes hear for the need for hate speech laws is the fear of the growth of far-right extremism. It is often put in these terms. To prevent something like we saw in 1920s and 1930s Germany happening again, the rise of fascism in the form of Hitler and Nazism, we need to censor hateful and offensive speech. In other words, the thought seems to be that speech restrictions, hate speech laws, would have stopped the Nazis. We have heard such rhetoric from our own politicians. Fianna Fáil Senator Lorraine Clifford Lee made this point in June 2023 during the second stage debates over the hate speech bill. She said, "It is acknowledged that the Holocaust did not happen in a vacuum." Sure, we all acknowledge that. It's difficult to get a Holocaust going in a vacuum. But she continues, "It is acknowledged that the Holocaust did not happen in a vacuum and that hate speech led to the Holocaust," which makes you think, acknowledged by whom exactly? She continues, "Speech leads to physical attacks on people. We need to make sure we do not allow anything like that to ever happen again." We do indeed need to do our best to make sure this doesn't happen again, but despite Clifford Lee's endorsement, hate speech law isn't the way to do it. What's happening here with Clifford Lee is she's jumping feet first, or even face first, into what is sometimes called the Weimar fallacy. I think someone who was mentioned earlier, I think you mentioned Eric Heinz, who he coined this phrase, the Weimar fallacy, after the Weimar Republic. This is the idea that the growth of the Nazis was somehow enabled by the lack of speech restrictions, as if, had they been in place, it would have stopped them. It is just not backed up by the historical evidence. The fact is, the Weimar Republic, they were hardly sitting on their hands during the 1920s. Not at all. The authorities did their best to suppress Nazi speech. They enacted laws criminalizing speech that have been compared to contemporary hate speech laws. One commentator of the Canadian Civil Liberties Association, Alan Borovoy, he has actually likened Weimar speech laws to current Canadian hate speech legislation. He writes, "Remarkably, pre-Hitler Germany had laws very much like the Canadian anti-hate law. Moreover, those laws were enforced with some vigor. Indeed, they were. Hitler himself was banned from speaking for 2 years in the mid-20s. Other leading Nazi figures such as Goebbels, Fritsch, and Streicher were convicted on grounds of hate speech. In 1922, a law was passed in Germany that permitted censorship of press criticism of the government. And this soon expanded into censorship of newspapers in general. The Weimar Republic shut down hundreds of Nazi newspapers. The crackdown on speech ramped up as the power of the Nazis grew. So Weimar Germany had laws banning hateful speech. And some of these laws focused in particular on anti-Semitic speech. These laws did not stop the Holocaust. On the contrary, these laws might be said to have enabled the growth of the Nazis. They were able to claim that they were victims of government oppression. In fact, just as Garton Ash said about the Holocaust denial laws, it was a very useful propaganda tool. The suppression of speech could be used as evidence to back up the grand Nazi conspiracy theory that Jews and communists were seeking to dominate Germany and silencing the real Germans. It might be compared to the notoriety that David Irving, the Holocaust denier, enjoyed as something of a martyr for free speech after his imprisonment in Austria. Moreover, it is worth adding, when the Nazis did come to power, they were able to use the hate speech laws on the books to their own benefit. As the CEO of the FIRE, Foundation for Individual Rights in Education, that's the old name, I can't remember the name, as Greg Luciano points out, the Nazis used these pre-existing means of censorship to crush any political speech opposing them, allowing for an absolute grip on the country that would have been more difficult or impossible with strong legal protections for press and speech. There is nothing then in the claim made unchallenged by Clifford Lee in our Senate that suppression of speech would have stopped the Nazis. Well, nothing apart from a display of ignorance. Now, if only more of our politicians could appreciate the words of Arya Nair, executive director of the ACLU in the 1970s, someone with direct experience in Nazi Germany who lost many members of his family to the Holocaust. He wrote this: "The chances are best for preventing a repetition of the Holocaust in a society where every incursion on freedom is resisted. Freedom has its risks, but suppression of freedom, I believe, is a sure prescription for disaster." Okay, let's return to the broader notion of genocide denial. There is a further effect of genocide denial laws that's worth considering. In a criminal case regarding an offence of genocide denial, the court is challenged not merely with meting out justice, but with determining the truth about historical events. And what the truth is in these matters will effectively be determined by the state. Take the case of the Nobel Prize-winning writer, the Turkish writer, Orhan Pamuk in 2005. Pamuk was put on trial in his native Turkey and ultimately fined for saying that the Ottoman Empire committed genocide against the Armenians in 1915. This was deemed an insult to Turkish dignity. It is an offense against Turkishness to claim that Turkey engaged in genocide. Pamuk made his comments in an interview with a Swiss magazine. Now, considering the genocide laws in Switzerland, it would have been interesting to see the consequences if Pamuk had denied the genocide. As a matter of fact, around the same time, around 2005, a Turkish politician and journalist, Doyu Perinçek, did just that. He publicly denied the Armenian genocide while speaking at conferences in Switzerland and was put on trial. In 2007, a Swiss court made him the first person to receive a criminal conviction for denial of the Armenian genocide. As Garton Ash quips, what was state-ordained truth in the Alps was state-ordained falsehood in Anatolia. Now, from the point of view of academic freedom, however, perhaps the most interesting case is that of the historian Bernard Lewis. Lewis, he held a chair of Near Eastern Studies at Princeton University. In 1990, he was invited to present the Jefferson Lecture, the highest honor the federal government confers for distinguished intellectual achievement in the humanities. And in 2006, he was awarded a National Humanities Medal by President Bush. He found himself on trial, first for a criminal prosecution, and then for, when that fell apart, for 3 civil complaints in France in the mid-90s for comments on the Armenian genocide that he made to a French newspaper. In an interview with Le Monde, Lewis had denied that the Ottoman massacre of the Armenians in World War I constituted a genocide. We consider his remarks on the matter. He said, "I am an historian and my loyalties are to truth. The concept of genocide was defined legally. It is a term that the UN used and the Nuremberg trials made use of as well. I side with words which have accurate meaning. In my view, a loose and ambiguous use of words is bad. The meaning of genocide is the planned destruction of a religious and ethnic group, and as far as is known to me, there is no evidence for that in the case of the Armenians." His point was that there was no serious proof that he could find of a decision and a plan of the Ottoman government to exterminate the Armenian nation. Now, the Lewis case is of interest because he was such a respected academic, and moreover, he was speaking about an area of his academic expertise. So academic freedom is implicated here. Now, the French court convicted him in a curious way. He was fined 1 franc, as it was a civil rather than a criminal procedure that eventually succeeded. But the court went so far as to say that Lewis was entitled to express his views, but that their expression harmed a third party, the Armenians who brought the case against him. So, this decision that he was entitled to his views, but they harmed a third party. If something like that were to happen here with the passing of the hate speech bill, it would be interesting to see how that squares with academic freedom as stated, for instance, in the Irish Universities Act of 1997. According to Section 14 of that Act, a member of the academic staff of a university shall have the freedom within the law in his or her teaching, research, and any other activities either in or outside the university to question and test received wisdom, to put forward new ideas, and to state controversial or unpopular opinions, and shall not be disadvantaged or subject to less favourable treatment by the university for the exercise of that freedom. Is this strong defence? It's a really strong defence of academic freedom. It's one of the strongest in Europe. Is this affected in any way by the provisions on genocide in our proposed hate speech bill? Now, one's first thought might be no. Firstly, because the section in question in the hate speech bill, it states that there must be intent to incite violence or hatred against a person or persons on account of their protected characteristics. But there is a worry here. One might take the position that genocide denial must always have insidious or sinister intent. Indeed, according to a paper published by the European Parliament, Holocaust Denial and the Law, they say Holocaust denial has been consistently presumed by the European Court of Human Rights to incite to hatred or intolerance, a presumption that allows for such incitement not to be proved in each case. So it's simply presumed. Holocaust denial is presumed to incite hatred or intolerance. What about all genocide denial, you might ask? Not just the Holocaust. What about denying the Armenian genocide? Is it not the same? No, it's not the same. Here things get a little bit cloudy. The court also declares in that paper, Holocaust denial, even if dressed up as impartial historical research, must invariably be seen as connoting an anti-democratic ideology and anti-Semitism. So it admits a distinction, it seems, in other words, between what it calls clearly established historical facts, such as the Holocaust, and, on the other hand, facts about which there's still ongoing debate among historians. So you might think that such things as the Armenian genocide slides into the second category. It's not yet an established fact, even though it happened in 1915, almost 30 years before the Holocaust. We go back to the Turkish journalist case, Perensek, which was the first conviction for genocide denial, and he was denying the Armenian genocide. On appealing his criminal conviction, the European Court of Human Rights actually ruled in favour of Perensek on grounds of his free speech. It determined, as such, Mr. Perensek was making a speech of a historical, legal and political nature in a debate. In other words, no intent to incite violence. Good for him. But Switzerland appealed this decision. It went to the Grand Chamber of the European Court of Human Rights. But again, they ruled in favour of Perensek's free speech rights. So you might say, well, all's well that ends well. Yes, until you notice that the final decision came in 2015, 8 years after his original conviction. As Ron Bunn put it, the process was the punishment. Now, that's one reason, right, investigate the connection between hate speech bill and academic freedom. Another reason why one might say that the hate speech bill, the genocide denial provision, does not affect academic freedom is that contribution to academic discourse is expressly protected in the proposed bill. In section 7, just before the genocide provision, it states, in any proceedings for an offence under this section, it shall be a defence to prove that the material concerned, or insofar as appropriate, the behaviour concerned, consisted solely of a reasonable and genuine contribution to literary, artistic, political, scientific, religious, or academic discourse. So academic discourse is protected. But perhaps that protection is not as reassuring as it ought to be. It brings into question what a reasonable and genuine contribution to academic discourse may be, and who is to be the judge of that. One might think, for instance, that remarks from someone as decorated as Bernard Lewis would rank as genuine and reasonable, even if, or especially if, one then decided to disagree with him. Now, there are many historians who disagree with Lewis, and thus think that the French court got it right. There does indeed appear to be a strong case against Lewis's interpretation, but the issue is this: do we want the courts to get involved in such issues? The point is that historians can and do make cases to refute interpretations. What we do not want is the state, through the courts, criminalizing interpretations. As one commentator put it, one need not support Lewis on the issue of the Turkish genocide of the Armenians to find odious the idea of anyone, especially a history professor, being hauled into court on hate speech charges. So-called hate speech laws are nothing but means of shutting down free speech by oppressors and ideologues in order to enforce ideological and political conformism. There are other ways to oppose and expose people like Lewis than hauling him into a court on bogus charges. Well said. Or, as someone who was mentioned earlier as well, by Theo, John Stuart Mill, he puts it very nicely. The peculiar evil, Mill writes, of silencing the expression of an opinion is that it is robbing the human race, posterity as well as the existing generation, those who dissent from the opinion still more than those who hold it. If the opinion is right, they are deprived of the opportunity of exchanging error for truth. If wrong, they lose what is almost as great a benefit, the clearer perception and livelier impression of truth produced by its collision with error. Now, that could do as a nice conclusion, but there's a tiny coda which I just want to mention, and just to finish off. It's interesting that the issue of the Armenian genocide, it came to Ireland last September. A delegation from Azerbaijan came to Dublin to attend the European Conference of Presidents of Parliament. While they were here, they visited the Oireachtas and were welcomed to the Distinguished Visitors Gallery and treated to a round of applause. They are very welcome, said Fianna Fáil Senator Niall Blaney, who was chairing a Shannon debate. And while at Leinster House, the Ceann Comhairle extended a céad míle fáilte and had a private meeting with the delegation and held a discussion with the chairwoman of the National Assembly, Sahiba Gafarova. This caused some controversy due to accusations that Azerbaijan is currently engaging in genocide in this ongoing conflict with Armenia. These criticisms were summarily dismissed. But something not commented on at the time was that Garifova, the leader of the delegation, who enjoyed a private audience with Ceann Comhairle, she gave a speech in 2021, which is available online, that denied the 1915 Armenian genocide. Moreover, she cited Bernard Lewis, along with some others, as authorities for her position. Both houses of the Oireachtas, in other words, stood to applaud a person who, were she to return and repeat publicly the main points of that speech in Ireland once this law has been inevitably passed, would presumably be committing a criminal offence, being in breach of the genocide denial section of the proposed hate speech law. So if you imagine for a moment that two houses of parliament in which the majority are in favour of pushing into a law a hate speech bill that criminalises genocide denial, welcoming and applauding, giving a warm céad míle fáilte to a delegation led by a genocide denier. Indeed, one would expect that every member of that delegation would also be of that opinion, as it is Azerbaijani government policy, as it is in Turkey, to deny the 1915 Armenian genocide. Fancy that. Thank you.